Hello, my name is Brant Hunt. My channel is Discerning What is True. Today is what is it, the fourth day? Yes, the fourth day of March, that is 2023. And I'm going to be reading chapter 2 from Fred Rodell's book, Woe Unto Lawyers. Mr. Fred Rodell was a former professor at the Yale Law School, as far as I know of. This book was written in 1939. Part of it, I think, was to do with him being upset, was to do with what I would call what was taking place with the Roosevelt administration. You see, I think Roosevelt came to power in 32. I think that's correct. 16, 20, okay, 24, 24. I think it is. Um, maybe some, don't hold me to that. Anyway, the chapter 2 is called The Law of the Lawyers. Here's a quote from W.S. Gilbert. The law is the true embodiment of everything that's excellent. It has no kind of fault or flaw. Okay? So the law is the Kitty Lou bird of the science, that is. And let me change something real quick before I get into this whole thing. Change it to a different color so it'll be easier for me to read. So here we go. The law is the Kitty Lou bird of the science. The Kitty Lou, of course, was the bird that insisted on flying backwards because it didn't care where it was going, but was mildly interested in where it had been. And certain the law, when it moves at all, does so by flapping clumsily and uncertainly along, with its eye unswervingly glued on what lies behind. In medicine, in mathematics, in sociology, in psychology, in every one of the physical and social sciences, the accepted aim is to look ahead and then move ahead to new truths, new techniques, new usefulness, that is. Only the law, inexorably devoted to all its most ancient principles and precedents, makes a vice of emulation and virtue of hoardiness. Only the law resists and resents the notion that it should ever change its antiquated ways to meet the challenge of a changing world. It is well nigh impossible to understand how the law works without fully appreciating the truth of this fact. The law never admits to itself that there can be anything actual new under the sun. Minor variations of old facts, old machines, old relationships, yes, but never anything different enough to bother the law into treating it otherwise than an old friend in a new suit of clothes. When corporations first came on the legal scene, the law regarded them as individual persons in disguise. And so, for most legal purposes, a corporation is still consistent and even talked about as a person. Correct. He's correct. A transport airplane, so far as the law is concerned, is nothing but a newfangled variety of stagecoaches. Such things as sit-down strikes, holding companies, Paris divorces were treated with almost contemptuous familiarity by the law when they first appeared, and the same fate undoubtedly awaits television when it grows up and begins to tangle with the law. All this is part of the carefully nurtured legend to the effect that the law is so omniscient that nothing men may do can ever take its unawares, and so all embracing that the principles which will apply to men's actions 500 years from now are merely waiting to be applied to whatever men happen to be doing in 2439 AD. What the law purports to be is a tremendous body of deathless truths so wide in scope and so infinite in their variation that they hold somewhere and often hidden within these vastness the solutions of every conceivable man-made dispute of problems, I should say, or problem. Of course, the truths are phrased as abstract principles, and the principles are phrased as in the strained limbo of the law. So only the lawyers, especially those who have become judges or ordained interpreters of the words, can ever fish the proper solution out of the law vastness. But it is the very keystone of the whole structure of a legal mythology to insist that all earthly problems can and must be solved by reference to this great body of unearthly abstractions, or in short, that they can and must be solved by the lawyers. The chief reason why it is so hard for the ordinary man to get the lawyer's picture of the law as a supreme massive changeless abstract principles is that the ordinary man generally thinks of law as a composite of all the little laws that his various governments are forever passing and amending and occasionally repealing repealing Congress and state legislatures and city councils keep laying down rules and changing rules. Is this not clear proof that the law moves with the times? Briefly, it is not. To the lawyer, there is a vast difference between the law and the laws. The law is something beyond and above every statute that ever has been or could be passed. As a matter of fact, every statute before the lawyers allow it to mean anything before they let it have any effect on the actions of men has to be fitted into the law by interpretation of what the statute means. And any apparent harmless little statute is likely to mean plenty to a lawyer, just as a statute which seems to carry dynamite in its words may mean nothing by the time the lawyers are through with it. A few decades ago, when the famous Clayton Act was passed, which was intended to preserve competition and crack down on monopolies, a strong labor lobby got Congress to write Section 20 into the new law. Section 20 had practically nothing to do with competition or monopolies. Section 20 was intended to restrict federal courts from granting so many injunctions against union activities. Samuel Gompers, Gompers, who was then the head man of the unions, called Section 20 labor's Magna Charta, that is, but Samuel Gompers was no lawyer. By the time the lawyers headed by the Supreme Court got through with Section 20, it meant exactly nothing. Chief Justice Taft, speaking for the lawyers, said it was intended to mean exactly nothing, referring to the law as an authority. He said that it was clear that Section 20 was no more than a restatement of the law as it existed before the Clayton Act was passed. Now, Chief Justice Taft was in no position to know and would have considered it irrelevant if he had known that the Clayton Act might not have been passed at all if it had not seemed clear to labor that Section 20 gave strikers the right to picket without constant interference by the federal courts. But Chief Justice Taft and his court of lawyers had the last word, you see. They made of labor, that is Magna Carta, something strangely resembling to Germany's scrap of paper, and all in the name of the law. Of course, Chief Justice Taft and his court would have found it far more difficult to do this if other lawyers had not played a leading part in writing the Clayton Act. Section 20 was full of those typical meaningless words like willfully, maliciously. It said, for instance, that federal courts could not stop strikers from picketing lawfully. Lawfully, according to Chief Justice Taft, meant in accordance with the law before the Clayton Act was passed. Before the Clayton Act was passed, the lawyers had ruled that just about all picketing was against the law. You see how they changed it, you see. Therefore, it still was, that is, QED, and incidentally, the Supreme Court did almost the same thing with the whole of the Clayton Act by picking on other meaningless legalistic words to prove that most trusts were not trusts, and most monopolies were not monopolies. According to the law, you can change the laws as all you please, but you can't change the law. And the law is what counts. It would moreover be a mistake to jump to the conclusion that Chief Justice Taft and his court interpreted Section 20 of the Clayton Act into a complete oblivion merely because they didn't like unions or strikes or picketing. For Taft, in the course of explanation at great lengths why Section 20 did not really mean a thing, went out of his way to include in his opinion a rousing defense of labor unions. Of course, this defense did not do the unions any good after Taft got through with it. The point is that Taft was insisting to his fellow lawyers, the only people who ever read or understand judicial opinions, that is disappointing the unions, he was merely following the law. The choice, however, distastefully, was forced upon him, for it is part of the legal legend that no lawyer, not even when he becomes a Supreme Court justice, ever does any more than explain why the law is and how it applies. He is merely the voice through which the great gospel is made known to man. Moreover, the law can do strange things to man-made laws, even when, as very rarely happens, such laws are not so full of willfullies and maliciously and lawfully that they practically invite the lawyer to write their own ticket. For example, there was the Guthrie Coal Act involving federal regulation of the coal industry. The Supreme Court first said that most of the important parts of the act were unconstitutional. Now, saying that a law is unconstitutional is really no more than a convenient way of saying that it goes against the law. But the whole idea of constitutionally and unconstitutionally is so mixed up with notions like patriotism and politics, as well as with the most sacred and complicated of all legal rules, that it deserves and will get full treatment a little later on. The point here is that after saying part of the Guthrie Act was unconstitutional, the judges went on to say that the good part had to be thrown out with the bad part. Not unreasonably, perhaps, on the fact of it. Not unreasonably until you learn that Congress, foreseeing what the Supreme Court might do with part of the act, had taken particular pains to write very clearly into the act that if part of it should be held unconstitutional, the rest of it should go into the effect anyway. And so in order to throw out the whole act, the court had to reason this way. Part of this law is unconstitutional. The rest is constitutional. Congress said the constitutional part should stand regardless of the rest, but that is not our idea of the proper way of doing things. We do not believe Congress would want to do things in a way that does not seem proper to us. Who really knows the law? Therefore, we do not believe Congress meant what it said when it said to let the constitutional part stand. Therefore, we will throw it out along with the unconstitutional part in the name of the law. That reasoning is not Virgilistic. It is a shortened version of part of what the Supreme Court actually said, through the court phrased it in a multiple symbolic legal language. In the case of Carter against the Carter Coal Company, and the result is an example more obvious, but no more extreme than thousands upon thousands of others of how little the laws written by so-called lawmakers really mean until the lawyers have decided what these laws mean or don't mean in the light of the law. Thus, the common man is dead wrong when he thinks of law as a conglomeration of all laws that are passed by legislation and written down in books, even though it is true that practically all these little laws are phrased by lawyers in legal language. Those little laws, those statutes, are to a lawyer the least important, least respectable of these three kinds of rules with which the lawyers deal. The only two kinds of rules are those that make up what lawyers call the common law and those that make up the constitutional law. Now, the common law is actually closer to the law with a capital L than any constitution or statute ever written. The common law is a set of rules that lawyers use to settle any disputes or problems to which no constitution or statute applies. There is, for instance, no written rule to tell the lawyers or anybody else whether a Nevada divorce is good in Pennsylvania. There is no written rule to tell whether a man who orders a house built with a bathroom between the kitchen and the pantry has to take the house and pay the bill. Has to take the house and pay the builder if everything else is fine, but the bathroom is between the living room and the coat closet. In both cases, the lawyer-judges write their own answers without interference from any constitution or statute. In both cases, the answer is said to be fished directly, nonstop, out of the mass of abstract principles that make up the law. Constitutional law is something else again. A constitution in this country, at least, is halfway between the law and an ordinary statute. Like a statute, it is phrased by men, a few of whom are usually not lawyers, and is written down in definite, if not often nebulous meaning words. Though in England, the Constitution isn't written down anywhere, and so it is indistinguishably from the law of England. But like the law, constitutions accept where they deal with the pure mechanics of government, as in giving each state 2 senators or listing the length of the government's term of office, are made of abstract principles which mean nothing until brought down to earth by the lawyers. If this sounds like heresy, consider, for instance, the U.S. Constitution well-known guarantee of freedom of speech. What does that guarantee mean? Practically speaking, It did not stop the federal government from putting people in jail during the in the World War, because they talked against war. It did not stop the police of Harlan County, Kentucky, from beating up people who tried to make speeches in favor of unions in Harlan County. On the other hand, that constitutional guarantee does prevent the extreme restrictions of free speech, which are common abroad today. How? How tell them which free speech is good and which is bad under the Constitution? Only by asking the lawyer-judges. And how can they tell? How do they decide? Simply by referring to our old friend, the law, in order to interpret the Constitution. The law is thus superior to Constitution, just as it is superior to statutes. You see where this is coming from, folks? It's almost though they make this up as they go along. That's my pun. And according to the legal legend, it is neither constitutions nor statutes which finally determine the rules under which men live. It is the law, working unimpeded to produce the common law, working through words of the Constitution to produce constitutional law, working through the words of both statutes and constitutions to produce statutory law. All three kinds of laws are merely obedient offspring of that great body of abstract principles which never changes, which nobody but a lawyer even pretends to understand. Justice Holmes was in effect talking about the law as a whole when he said, of the nearest and dearest offspring. The common law is not a brooding omnipresence in the sky, but Justice Holmes, as he well knew when he said that, was dissenting not only from a decision of the Supreme Court, but from the opinions of most lawyers about the law. Practically every lawyer thinks and talks of the law as a sort of an omnipotent, omniscient presence hovering around like God over the affairs of men. Yet every lawyer purports to be able to understand and interpret a large part of that presence for the benefit of those who are not lawyers, at a price. The strange thing is, however, that lawyers, for all their alleged insights into the great mystery, are never able to agree about the presence or its interpretation when it comes down to applying the law to a simple, specific, factual problem. If the lawyers agree, we would not have appellate courts reversing the judgments of trial courts, and super appellate courts reversing the judgments of appellate courts, and super appellate courts, or Supreme Courts reversing the judgments of super appellate courts. The fact is that every lawyer claims to know all about the law to a specific dispute, whereas no non-lawyer cares in the slightest degree what the law is until it comes down to applying the law to a specific dispute. It is all very well for a lawyer to say out of his knowledge of the law that a mortgager, that is, has legal title to a building. That is very pretty and sounds very impressive. But if the mortgager then wants to know if he can sell the building and on what terms, and if he has to pay taxes on it, and if he can kick the mortgagees out of it, the mortgagees come snooping around. The lawyers will begin to disagree. It is all very well, too, for a lawyer to say that the law forbids interference with the freedom of contract. But when 57 respectable lawyers of the late Liberty League declared unanimous that employers need pay no attention to the Wagner Labor Act because it interferes with freedom of contract, then the Supreme Court tells them they are 100% wrong. The 57 lawyers' undoubtedly knowledge of the law begins to look just like a triple feudal. The law, as a matter of fact, is all things to all lawyers. It is all things to all lawyers simply because the principles on which it is built are so vague and abstract and irrelevant that it is possible to find in these principles both a justification and a prohibition of every human action or activity under the sun. Correct. They can weigh things, do these things, and say, this is different what it was in this particular area, and this is such and such year, and you're like, wait a minute. This is a law. Why isn't it solid? Why is it foundation-wise, you see? No, it's depending on what varies, this and that. It changes everything, you see. So, and how does the law then ever get brought down to earthly affairs? In what way does it actually succeed in building regulatory fences against men's conduct? The answer is just as simple as it is complex. The answer is that the last bunch of judges who should get a shot at the solution of any specific problems have the decisive word of the law as it affects that problem. The solution which that last bunch of judges gets to the problem is the law, so far as that problem is concerned, even though every other lawyer in the world might suppose the law was different. it might not then been irrelevant to ask just what a judge is. And it was a unusual candidate judge who recently gave the best answer to that question. A judge, he said, is a lawyer who is a lawyer who knew a governor. Holy crap. The lawyers who knew governors, of who knew presidents, or who knew enough ward leaders, that is ward, W-A-R-D, leaders, where judges are elected, bring the law down to earth in all sorts of different and conflicting ways. A homeowner who beats up a trespasser hobo may be a hero in one state and a criminal in another. But no matter which he is, the legal appraisal of his actions will fit perfectly into the great and ubiquitous framework of the law. No matter how different judges in different places may decide the same human problem or decide it differently in the same place at different times, the great legend of the law, as steadfast and all-embracing, is always adhered to. Decisions may change or differ or conflict, but the law budges not. And it is necessary to understand this keystone of legal reasoning and to accept it as a fact, no matter how silly it may sound, before it is possible to understand the strange processes of the law. It is necessary to realize that the law not only stands still, but is proud and determined to stand still. If a British barrister 200 years ago were suddenly to come alive in an American courtroom, he would feel intellectually at home. The clothes would astound him, though. The electric lights would astonish him. The architecture would astonish him. But as soon as the lawyers started talking legal talk, he would know that he was among friends. And given a couple of days with the law books, he could take the place of any lawyer present or of the judge and perform the whole legal mumbo jumbo, as well as the, imagine by contract. A business surgeon of 200 years ago plopped into a modern hospital operating room. He would literally understand less of what was going on than would any passerby brought in from the street at random. But the law alone and of all the sciences just sits aloof and practically motionless. Constitutions do not affect it, and statutes do not change it. Lawyers talk wise about it, and judges purport to apply it when they lay down rules for men to follow. But actually, the law, with a capital L, has no real relation to the affairs of men. You see, it is permanently and changeless, which means that it is not of this earth. It is a mass of vague, abstract principles, which means that it is a lot of words. It is a brooding omnipresence in the sky, which means that it is a big balloon which has thus far escaped the legal pen. So that's the conclusion of chapter 2 tonight with Woe Unto You Lawyers by Fred Rodell. It's just interesting how it simply it changes. This is what I see, what he's trying to say. What might have been legal or illegal back in the 1700s or 1800s is now different. You see? So the law itself is what he's saying. It moves with the times, it seems to be, which is a really scary thing, because that means simply it is no longer foundational. It doesn't have any principles, you see. And it can be judged by a particular judge one time. And like he says, also, the higher up that you go, you have the last say on that particular ruling. It's kind of scary, isn't it? It should scare the hell out of you, because frankly, that's how things are done here in this country. And I'm sure they're also elsewhere. But this country has more lawyers per capita than any other country in the world, because that's where they make their money. They make money off of, quote unquote, any kind of suits. It takes place anywhere. And there's plenty of money to go around, you see. So that's how they do this thing. So anyway, I don't want to go into a whole lot of detail, but anyway, I wanted just to read that chapter 2 for you from Fred Rodell, talking about woe unto lawyers. So again, thank you for being here, and I hope that you're learning something. Again, Fred Rodell was a professor of law at Yale University. He was truly frustrated by writing this book, because he simply was like, well, if the Constitution, like I say a lot of times, if the Constitution of the law is the law of the land, it is the law of the land until you change it. And how do we have that? The only way you change it is simply here in America, simply is you get amendment. and you pass it in the House and Senate. And then you have to get 3/4 of the states to go along with it. That's how you get an amendment. You don't come along with a legalese along and say, oh, we don't do that anymore. You see, no, the Constitution is the law of the land. You see, that's the foundation of this country. But we have lawyers now who circumvent the law. And I don't know if he'll go into this part or not, but what's happening circumventing simply is that they just simply ignore it and say, oh, no, we're in a different time age now. Things are different. We have a different perspective. This is how we look at things. So what they're doing is putting what I call a presupposition in what they're going to judge it to be. So a long time ago, when some man murdered someone 100 years ago, 75 years ago, 50 years ago, well, that was treated as simply as he broke the law, and he's going to be punished in a very harsh way. Either he's going to be killed, or he's going to stay in prison for a long, long time to pay back the community and what he did to the particular person. But now it's a completely different ballgame. It's wishy-washy. And it's also a circus in many ways. If you go watch some of this stuff, go to the courtroom and see what's going on, you see simply is that they're arguing this way and that way. And it's just, a lot of it's a circus. In fact, to me, it is a circus, you see. And the sad part is that there are 4 people in there who benefit. And I've shared this with other people in a particular other book I've shared in the past. And the defense and the prosecutor and the court, the judge and the court reporter are all working there to get a judgment to benefit themselves. It's to make money, which Mr. Rodell doesn't know about yet. But I have shared videos probably a month ago with this whole the whole idea of what's going on about the legal name and not your real name. You see, all that capital, all caps letters, all this kind of thing, and more than that. You see. Anyway, it's getting late here, and I don't want to continue keeping people up. Plus, I'm staying up myself. But I wish you a good night, and hopefully this will glean some more wisdom to your ears for those who have ears to hear, for those who have eyes to see. Have a good night. Take care.